Welcome to the deep dive. Today we're heading back into the foundational world of contract law, but we're going beyond, the classic trio offer, acceptance, and consideration. We're going to unpack some absolutely crucial and sometimes, well, trickier requirements that courts look at.
That's right. We're diving deep into sort of the underlying intent of the parties. Do they really want their agreement to have legal force? That's a big one.
Yeah.
And we'll explore the need for clarity in the terms themselves, like just how certain do those terms need to be.
Okay.
And finally, completeness, making sure the parties have actually, settled on all the essential bits of their deal. These elements, they're just as vital as the initial promises.
Absolutely. And guiding us on this journey, we've got some incredibly valuable material, very generously made available for educational purposes by the University of London.
Absolutely. And it's great material. This deep dive specifically is brought to you by Sinorbit Academy, Sri Lanka, and it's designed to help you prepare thoroughly for your studies and exams.
So, yeah, to all of you out there getting ready for your exams, putting in all that hard work seriously, we wish you the very, very best of luck. You've totally got this.
Definitely.
Let's dive right in and unpack this fascinating topic.
Okay. So our mission today is basically to pull out the most important nuggets of knowledge from this material. We want to cover all the key concepts, the big cases, the ones you really need to know, and the reasoning behind them, just to make sure you're really well equipped.
Right.
And we're jumping straight into that first critical requirement, figuring out whether the parties actually intended for their agreement to have legal weight, in the eyes of the law.
Okay, let's unpack this first hurdle then. Intention. We've sort of touched on intention before, haven't we? Like, an offer needs intent to be bound if accepted. But here, it feels broader somehow. It's not just about the offer itself. It's about the whole agreement. Do the parties intend for the whole thing, the deal, to have legal consequences?
Precisely. That's exactly it. This element, intention to create legal relations, it means the parties must intend their agreement to be legally binding, enforceable.
Okay.
It means they're thinking, maybe subconsciously, that if something goes wrong, they could, take the issue to court, or maybe an arbitrator.
Right, an external adjudicator.
Yeah, and that adjudicator would actually recognize it as a contract and could provide a remedy. It's about stepping beyond just a casual promise, of a friendly understanding, or maybe just a moral obligation.
Right.
You're moving into the realm of legal rights and duties.
I get that. But if you have offer, acceptance, consideration, all those pieces, why isn't that automatically enough? Why this extra layer of intention?
That's a really good question.
Yeah.
And the need for it becomes most obvious, and frankly, where the law is most developed, in those domestic and social agreements.
Ah, okay. Family and friends stuff.
Exactly. Agreements between people in close relationships. Family, spouses, friends. Think about everyday life. You agree to meet a friend for coffee. There's offer, acceptance, maybe some consideration, like just enjoying the chat.
Sure.
But neither of you expects to get sued if someone has to cancel, right?
Right. Of course not.
Or the example you gave earlier, promising to bring dessert to a party. Elements look like a contract, maybe, but there's zero intention to face legal action if you forget the cake. The law gets that lots of agreements aren't meant for the courts.
That makes total sense. So the law kind of categorizes agreements to get a starting point on intention.
Exactly. Traditionally, English law uses this key distinction based on the context, and it sets up what we call rebuttable presumptions. Just starting points, mind you.
Okay, presumptions, what are they?
Okay, first up, domestic and social agreements. So between spouses, parents, and kids, close friends. Here, the law generally presumes there is no intention to create legal relations. Let me repeat that. Domestic and social agreements have a presumption against intention.
Against intention, okay.
The idea is these agreements are built on trust, affection, convenience, not legal enforceability.
Got it. And the other type?
Commercial agreements. So business context, parties dealing commercially, often called at arm's length. Here, the presumption flips. The law presumes there's an intention to create legal relations. Repeat. Commercial agreements have a presumption for intention.
For intention, okay.
The assumption is business people generally mean for their deals to be legally binding. It's sort of the bedrock of commerce.
But you said rebuttable presumptions, so not set in stone. The facts can change things.
Absolutely. Crucially important. They're just starting points. The specific facts and circumstances of any case can knock down these presumptions.
Okay.
Like, say, two neighbors who are also friends, right? But they drop a really formal written agreement. Maybe one pays the other to landscape their garden, detailed terms, signatures.
Yeah.
That formality might be enough to rebut the usual no-intention presumption for social agreements. The whole context surrounding the agreement is key.
Okay, so how do courts actually figure out this intention? Do they try and read minds? Like, what were they really thinking?
No. That would be trying to use a subjective test, and that's just too tricky, too unreliable. People's private thoughts. Hard to know. They might even change their story later.
Right.
So instead, the law uses an objective test. Courts don't ask what the parties secretly felt. They ask. Looking at everything, all the circumstances, what would reasonable parties in this situation have intended? Would a reasonable outsider think these people meant to make a legally binding deal?
Okay, objective test based on context.
Exactly. The material rightly stresses that. The test is objective. What would reasonable parties intend based on the context? We see this in cases like Edmonds v. Lawson. Let's repeat that. Edmonds v. Lawson.
Edmonds v. Lawson.
That involved a pupil barrister and her chambers. Looked a bit like employment, maybe, but the court applied an objective test to the whole context of barrister training. They asked objectively, was there an intention to create a contract of employment?
And this objective test, it works for both types, social and commercial.
Yes, absolutely. Even in situations that might seem like employment on the surface. Take the case of the Methodist minister and president of the Methodist Conference v. Preston. Repeat. President of the Methodist Conference v. Preston.
President of the Methodist Conference v. Preston.
The minister got accommodation, a stipend. It looked a bit like employment terms, but the Supreme Court looked objectively at the whole picture. The church rules, the spiritual nature of the role, the minister's status within that structure, and found no intention to create contractual relations. So it's not just about labels, it's that objective assessment of the full context.
Got it. Let's dive deeper into the domestic and social side first then, where the presumption is against intention. The material points to a really big case here.
Ah, yes. The absolute classic. The one everyone learns. Balfour v. Balfour. Repeat. Balfour v. Balfour.
Balfour v. Balfour, 1919, right?
That's the one. Court of Appeal. The facts are pretty straightforward. Mr. and Mrs. Balfour lived in Ceylon. He worked there. They came to England on leave. But when he had to go back, Mrs. Balfour was ill. Doctor said she shouldn't travel. So he promised her 30 pounds a month for maintenance while they were apart because of her health.
Sounds reasonable.
But later they separated permanently. And Mrs. Balfour sued him to enforce that promise of 30 pounds a month.
And the court said?
No contract. The court found there was no enforceable agreement. Warrington L.J. said it was not intended by either party to be attended by legal consequences. Basically, it lacked that intention to create legal relations. Her claim failed.
Why, though? Just because they were married? Was that the only reason?
Well, that was a huge factor, definitely. But Lord Atkin's judgment, which is the one most often quoted, went a bit further. He brought in this public policy argument.
Public policy? How so?
He basically said agreements between spouses when they're living together amicably are outside the realm of contracts altogether. These everyday promises about housekeeping money, allowances, things like that, they're based on love, affection, trust, not cold hard law. And he worried if courts started enforcing every little domestic arrangement, they'd be completely overwhelmed, flooded with trivial disputes between family members. It was partly about keeping the courts out of private family life, the famous floodgates argument.
Okay, the floodgates. Were there other cases that followed this Balfour idea?
Oh, yes, definitely. The Balfour principle got applied in lots of family situations. Jones v. Padavatten is another key one. Repeat. Jones v. Padavatten.
Jones v. Padavatten.
This extended the presumption against intention to agreements between a mother and her adult child. The mother convinced her daughter to leave a good job in the U.S., move to London, study for the bar, promising her an allowance.
Right.
Later, they changed it. The daughter lived rent-free in a house the mother bought. But then they fell out. The court looked at both arrangements, the allowance, the house, and said neither was a binding contract, just family arrangements based on trust, lacking that legal intent.
And it wasn't just immediate family, was it? What about friends?
Right. The case of Coward v. MIB is an example. Repeat. Coward v. MIB. This was an informal deal between friends, colleagues actually. One gave the other lifts to work, and the passenger chipped in for petrol money. The court said, nope, no contract there, just a friendly gesture, cost sharing, not a formal transport agreement meant to be legally binding.
So that presumption against intention in domestic and social life is pretty strong then, but, like you said, rebuttable. What does it take to actually knock it down? What kind of facts overcome it?
Okay, so the presumption gets weaker or can be rebutted entirely when the context isn't your typical harmonious family setup, or when the parties do something that signals more formality, more seriousness.
Like what?
The biggest factor, often, is relationship breakdown. Look at merit v. merit. Repeat, merit v. merit.
Merit v. merit.
Now, the facts look a bit like Balfour spouses' finances, but the crucial difference. They were already separated when they made the agreement about the house. He agreed, in writing, to transfer his share to her if she paid off the mortgage.
Writing and separation.
Exactly. Because they were separated, dealing at arm's length, really, and they put it in writing, the court said the usual presumption was rebutted. They did intend to create legal relations. It was a binding contract.
Okay, separation is key. Any others?
Yeah, Dark v. Stroud is another good one. Repeat. Dark v. Stroud.
Dark v. Stroud.
Agreement for child maintenance between parents after they'd split up. The court found intention there. What influenced them? Partly the formality it was in a letter, and partly because the woman, by accepting this private agreement, was potentially giving up her statutory rights to seek maintenance through the courts. That suggested a more serious binding arrangement.
Giving up rights, okay.
And another, Salisbury v. Salisbury. Repeat. Salisbury v. Salisbury.
Salisbury v. Salisbury.
Court of Appeal found intention between former spouses. One agreed to stop claiming maintenance payments in return for getting a specific bequest in the other's will. Again, seen as a serious bargain for deal-resolving finances after the relationship ended. That points towards legal intent.
It really seems like separation or the relationship already being over is a huge factor in rebutting that domestic presumption. What about agreements made before marriage? You know, prenups, they seem pretty serious.
That's a very relevant modern area, absolutely. Radmacher v. Granatino is the landmark Supreme Court case. Repeat, Radmacher v. Granatino.
Radmacher v. Granatino.
Now, the court didn't quite say prenups are automatically 100% binding in all situations, but they ruled that courts should give decisive weight to a prenup in a divorce settlement as long as it was entered into freely with full understanding.
So they do intend legal consequences.
Implicitly, yes.
Yeah.
The ruling acknowledges that people making prenups do intend them to have significant legal effect if the marriage ends. It's a big shift from the past reluctance to see marital agreements as legally serious.
But wasn't there some disagreement on the court?
Yes, absolutely. Lady Hale gave a very powerful dissenting judgment in Radmacher. She raised really important concerns about potential pressure, inequality of bargaining power before marriage. She argued prenups shouldn't automatically be treated the same as post-separation agreements like in marriage, where the parties are clearly acting independently. Her dissent really highlights that there's still an ongoing policy debate here.
Okay, fascinating. What about social agreements that aren't family, like friends going halves on a lottery ticket, or entering competitions together? Same principles.
Pretty much the same approach. Start with the presumption against intention, but then look really closely at the facts to see if it's rebutted. The cases are very fact-dependent here.
Right.
Simpkins v. Pays is an interesting one. Repeat, Simpkins v. Pays.
Simpkins v. Pays.
This involved a landlady, her granddaughter, and a lodger. So not strictly family, but living together, a domestic setting. They regularly entered newspaper competitions together, share the entry costs, clear understanding they'd split any winnings.
Okay, sounds like a system.
Exactly. When they won, the landlady tried to keep it all. But the court said, no, there was a contract to share. The regularity, sharing the costs, the clear agreement on splitting the prize, it all pointed towards a joint enterprise, something more than a casual chat. It rebutted the presumption.
But other cases go the other way.
Yes, compare that to Wilson v. Burnett. Repeat, Wilson v. Burnett.
Wilson v. Burnett.
Two friends went to bingo, one won big. The other claimed they'd agreed to share winnings. The court found no binding contract. The conversation about sharing was seen as just loose talk, wishful thinking perhaps, not a concrete agreement intended to be legally binding.
So it really boils down to the specific facts. How clear and serious was the arrangement?
Precisely. The Materials Activity 4.2 asks about the difference between Simpkins and Coward v. MIB, the lift sharing case. It's about that level of structure and commitment. Simpkins looked like a deliberate joint venture with a system. Coward felt much more like an informal favor with some cost sharing.
That difference between just chatting about something and actually forming a more structured deal, even informally, seems crucial. Let's try applying this. Activity 4.3. Married couple agrees, one pays mortgage, other pays bills, one stops. Can the other sue?
Okay, standard scenario. Applying Balfour v. Balfour, the strong presumption is against intention. They're married, living together. It's a typical domestic financial arrangement. Unless you've got really unusual facts like a super formal written document spelling it all out, maybe linked to some other major concession, or perhaps the agreement was made when they were already separating, a court is almost certainly going to say no contract. It's just part of the give and take of marriage, not legally enforceable.
Okay. And activity 4.4. One partner pays expenses, the other cares for kids. Then the caregiver gets a paid job. Does the first partner have to keep paying the expenses contractually?
Again, sounds like a standard division of roles within a relationship. Following Balfour, it's highly unlikely a court would find a contract there. The original arrangement, while vital for the family, almost certainly lacked that intention to be legally enforced if things changed.
Right.
And the sample exam question in the material really tests this. You've got different scenarios. Mother-son, uncle nephew, boyfriend, girlfriend. For each one, you have to, first, identify the relationship, domestic, social. Second, state the presumption against intention. Third, scour the specific facts given for that agreement. Is there formality? A relationship breakdown? Significant reliance? You use cases like Jones v. Padavatten for the mother-son, maybe Coward or Wilson for the others. But always remember, Edmonds v. Lawson, the ultimate test, is objective intention based on all the facts, not just the relationship label. Right, the label gives the starting point, the presumption, but the objective facts determine if it's rebutted. Okay, makes sense. Let's switch gears then. Commercial agreements, the presumption flips here, right? Yes, exactly. In a commercial setting, courts start from the opposite position. Strong presumption that the parties did intend their agreement to be legally binding. That's the default expectation in business.
So it's much tougher than in a business deal to argue there wasn't a contract intended.
Generally, yes. The burden of proof really shifts. The party claiming there was no intention has to bring clear evidence to knock down that strong commercial presumption.
Any examples?
Sure. The material mentions Athena Brands v. Superdrug Stores. Repeat. Athena Brands v. Superdrug Stores.
Even just an email exchange where they agreed on minimum purchase quantities for cosmetics that was found to be a binding contract. Why? Clear commercial context, language indicated commitment.
Okay. Emails count.
And the inference for intention is especially strong in ongoing employment relationships, like in Dresdner-Kleinwort, Ltd v. Atril. Repeat. Dresdner-Kleinwort, Ltd v. Atril.
Dresdner-Kleinwort, Ltd v. Atril. That case involved promises made to employees about bonuses. In that employment context, promises relating to remuneration are generally presumed to be intended as legally binding.
But businesses can choose not to be legally bound, can't they, if they deliberately structure things that way?
Oh, absolutely. Party autonomy is key here, too. They can displace that strong commercial presumption, but they have to be really clear about it, usually through express wording in the agreement itself.
How do they do that?
The most common way, especially in things like property deals or complex negotiations, is using the magic words, subject to contract. Repeat, subject to contract.
Subject to contract.
Putting that phrase in an agreement signals loud and clear, we don't intend to be legally bound by this document. Binding agreement only happens when we sign the final formal contract later. It explicitly rebuts the presumption.
Are there other ways besides subject to contract?
Yes. Sometimes it's the nature of the document or specific clauses. The material mentions comfort letters. You see these sometimes where a parent company gives a letter to someone lending money to its subsidiary.
Okay.
These letters might say things like, "We have confidence in our subsidiary," or "It's our policy they meet their debts." But they're often carefully worded not to be a legal guarantee. Kleinwort Benson, Ltd v. Malaysia Mining Corporation, Berhad, is the case for this. Repeat. Kleinwort Benson, Ltd v. Malaysia Mining Corporation, Berhad.
Kleinwort Benson, Ltd v. Malaysia Mining.
Okay. The court looked very closely at the wording and decided it was just a statement of current fact or policy, not a binding promise to pay if the subsidiary defaulted. It lacked contractual intent.
Interesting. Anything else?
Yes, the honor clause. This is where parties explicitly state in their agreement that it's binding in honor only, not legally.
Binding in honor only.
Exactly. The classic case is Rose and Frank Company v. J.R. Crompton and Brothers Ltd. Repeat, Rose and Frank Company v. J.R. Crompton.
Rose and Frank Company v. J.R. Crompton.
They had a detailed written agreement, commercial context, everything looked like a contract. But it contained a specific clause, the Honorable Pledge Clause, saying it wasn't a formal legal agreement, just binding in honor. The House of Lords said, well, the parties made their intention crystal clear, even though it was commercial. They explicitly excluded legal enforceability. So no contract.
So even in a business deal, if you clearly say this isn't legal, just honor, the courts will respect that.
Precisely. The objective test still applies. Remember Edmonds v. Lawson again. What would reasonable business people understand from words like subject to contract or an honor clause? They'd understand no legal intention yet or no legal intention at all. But absent such clear signals, most arm's-length commercial deals will be found to have intention.
What about those interesting recent cases, business deals discussed in pubs or restaurants? How do they fit? Can the setting rebut the commercial presumption?
Ah, yes. Blue v. Ashley and McInnes v. Gross. Repeat. Blue v. Ashley and McInnes v. Gross. They're great examples of the objective test in action, even with experienced business folk. In Blue v. Ashley, the claimant said Mike Ashley promised him £14 million in a pub if the Sports Direct share price hit a certain target.
In a pub? $14 million?
Yeah. Legage said no intention to create legal relations. Why? He looked at the whole picture. Yes, the pub setting, the drinking, the informal chat, the banter, but also the vagueness of how the bonus would work. And crucially, the parties' conduct afterwards didn't suggest either thought a serious binding deal had been struck. It just didn't look like a real contract objectively.
Okay. And the other one, McInnes v. Gross.
Similar idea. Alleged oral agreement about paying a consultant, made over dinner in a posh restaurant. Again, court said no binding contract at that point. Why? Even though it was high-end, it was still dinner. And more importantly, emails after the dinner showed they both expected detailed terms and conditions to be hammered out and formally agreed later. That indicated the dinner chat wasn't intended as the final binding agreement.
So even between business people, the whole context matters. Where, how, what was said, what happened next. An informal setting plus other factors can rebut the presumption.
Exactly. It's all part of the objective assessment.
Now, Activity 4.5 asks an interesting question. Why would a commercial party deliberately want an agreement not to be legally enforceable? Is there any point?
That's a really practical point. There are good reasons. Sometimes they use non-binding documents like memoranda of understanding or letters of intent as a first step. It outlines the basic plan, builds trust, maybe allows due diligence, but keeps things flexible.
So they can walk away easily.
Right, without risking being sued for breach if something comes up or if they can't get internal board approval, for example. It allows cooperation and planning without the immediate threat of litigation. So while not legally binding, these agreements aren't useless. They provide a framework, a moral commitment maybe, guide negotiations. Their value isn't legal enforceability, but facilitating the process. Okay, so let's quickly recap intention. It's a vital objective test. Would reasonable parties think this agreement was meant to be legally binding? We have presumptions against intention in domestic social settings, Balfour v. Balfour. For intention in commercial settings, Athena Brands. But importantly, both are rebuttable. You rebut them by looking at the specific context, formality, relationship breakdown, merit v. merit, express words subject to contract, honor clauses like in Rose and Frank, or the overall objective picture, Blue v. Ashley, McInnes v. Gross. No intention, no contract. End of story for that element.
Okay, that's intention covered really well. It shows contract law isn't just ticking boxes. It's looking at the reality of the agreement. All right, let's move to the second crucial element. Certainty of terms. This feels like where things can get really messy. So, okay, we've got intention. The parties meant business, legally speaking. What's next? Why does it matter so much that the terms are clear? Certainty.
Well, an enforceable contract needs its terms to be sufficiently clear and certain. If the essential parts of the deal are too vague, too ambiguous, or just haven't been properly settled, then the agreement won't be recognized as a contract by the court.
Why not? Can't the court just sort of figure it out? Use common sense.
It comes back to the court's role. Their job is to interpret and enforce the deal the parties made. It's definitely not their job to make the contract for them. If the terms are fundamentally uncertain, the court can't know what the parties' rights and obligations actually are without basically guessing or writing terms the parties themselves never agreed on. That crosses the line from interpretation into creation. And if the terms are too uncertain, you could argue there was never really a true agreement in the first place. No meeting of the minds, no consensus ad item on the crucial bits.
Consensus ad item. Okay. Is there a key case for this?
Oh, yes. The classic is Scammell v. Houston. Let's repeat that. Scammell v. Houston.
Scammell v. Houston.
This involved selling a van. The agreement said part of the price would be paid on hire purchase terms over 2 years.
Sounds specific enough.
You'd think, but the House of Lords said no, unenforceable. Why? Because hire purchase terms was too vague. Back then, there were loads of different types of hire purchase agreements, all with different clauses. Since they hadn't specified which kind or the details, there was no objective way for the court to know what they'd actually agree. Too uncertain. No contract.
Wow. So does any lack of clarity kill the contract?
Not necessarily, no. Courts do try to make agreements work where possible, especially if the parties clearly intended a deal. They won't let a contract fail just because a term is a bit ambiguous or hard to interpret, as long as it's not, quote, legally or practically impossible to give it any sensible content. That phrase comes from Scammell v. Dicker. Repeat, Scammell v. Dicker.
Scammell v. Dicker. Okay. So they try to find sensible content.
Yeah, they'll use tools like looking at the whole contract, context, applying business common sense, maybe looking at established trade customs or previous dealings between the parties.
Can you give an example where they did find enough certainty?
Sure. Durham Tees Valley Airport v. Be My Baby. Repeat. Durham Tees Valley Airport v. Be My Baby.
Durham Tees Valley Airport v. Be My Baby.
The agreement was for the airline, Be Me Baby, to base and operate 2 aircraft from that airport for 10 years. But it didn't specify exactly how many flights or minimum passenger numbers.
Sounds a bit vague.
It does, but the court held it wasn't void for uncertainty. They looked at the core obligation an airline committing to operate from an airport and decided there was enough certainty there. They felt commercial common sense could fill in some gaps about how that operation would work in practice over the 10 years.
Okay. Are there times when courts are sort of more inclined to find certainty, maybe imply terms?
Yes, definitely. A really important factor is whether the parties have already acted on the agreement. Have they relied on it? Started performing their side of the bargain?
Reliance and performance.
Exactly. That can make a big difference. Look at Hillis v. Arcos. Repeat. Hillis v. Arcos.
Hillis v. Arcos.
Timber case.
That's the one. Contract to supply timber. But it also included an option for the buyer to get more timber the next year, described vaguely as a fair specification. Seller argued the option was too uncertain.
House of Lords said the option was enforceable. They looked at the vague phrase, fair specification, in context. They considered the previous dealings, the established way things were done in the timber trade, and the fact it was a commercial deal they clearly intended. They were willing to interpret the phrase based on all that background and the parties' actions.
So context and trade usage help there. Activity 4.7 asks us to compare Hillis and Scammell. What's the key difference?
It really comes down to whether the court can find a meaning. In Hillis, despite the vagueness, the context past dealings, trade custom provided a way to interpret fair specification. In Scammell, hire purchase terms was just too open-ended. It was a fundamental term left completely undefined, with no specific trade usage or context to pin it down. It prevented that consensus ad item.
Got it. And performance is important, too.
Hugely important. Look at RTS Flexible Systems, Ltd v. Molkeray Elois Muller. Repeat, RTS Flexible Systems, Ltd. The Muller yogurt case. That's it. They started the work installing automated machinery, even though the formal written contract wasn't finalized. The Supreme Court said, looking objectively at everything they'd said and done, especially starting performance on terms that seemed agreed were economically significant, they had reached a binding agreement by that point, even if some minor bits were still being negotiated.
But performance isn't always enough, is it?
No, it's not a magic bullet. Contrast RTS with British Steel Corp v. Cleveland Bridge and Engineering Co. Ltd. Repeat. British Steel Corp v. Cleveland Bridge.
British Steel Corp v. Cleveland Bridge.
British Steel made steel nodes for Cleveland Bridge, basically at their request, while contract talks were dragging on. Performance was almost complete. But key terms, price, delivery, were never agreed throughout the whole process. The court said no contract ever came into existence. Fundamental terms were missing. British Steel got paid for the work they did, but on a restitutionary basis, quantum merit, not because there was a contract.
So even lots of performance can't save it if core terms were never actually agreed.
Exactly. It shows courts are trying to balance things. Not impose a contract where none exists, but also not let parties escape easily if they've acted like they had a deal, especially if the other side relied on it.
It's a tricky line.
It is. Another way to get certainty, even if a term isn't fixed now, is if the agreement provides a clear mechanism to fix it later.
Like a formula.
Yeah, or referencing an external standard. Like the price will be the market price on X date, or the interest rate will be 1% above the Bank of England base rate on the payment date. The term isn't fixed yet, but the method for fixing it is certain. That works.
Okay. You mentioned vagueness earlier. How is that different from being incomplete, like a term is just missing.
It's a subtle difference. Vagueness is usually when a term is there, but its meaning is unclear. Incompleteness is when an essential term hasn't been agreed at all, or maybe they've explicitly said, we'll agree this later. Now, if a term is just completely meaningless, utterly nonsensical, like referring to usual conditions when there aren't any, the court might just ignore it, sever it, and enforce the rest of the contract if what's left still makes sense as a complete deal. Nicolene Ltd v. Simmons is the case for that. Repeat, Nicolene Ltd v. Simmons.
Nicolene Ltd v. Simmons. Ignore meaningless terms.
But if an essential term is missing or deliberately left to be agreed later, that's incompleteness, and that usually means no contract. Which leads us nicely into our next point.
Before we get there, just to sum up certainty, essential terms need to be clear enough for the court to understand and enforce. Courts won't write the deal, but they'll use objective interpretation, context, trade usage, agreed mechanisms. And reliance or performance can make them more willing to find certainty, but won't rescue an agreement if fundamental terms were just never settled.
Perfect summary.
And connecting back to that sample exam question, the Uncle FU deal about staying in the house, the advice flags a lack of certainty. How long? Which bit? Could be too vague, like Scammell. Or could context or conduct allow a court to infer terms, maybe like Hillis or Foley? It depends on the specifics.
Precisely. And that self-assessment question about reasonable endeavors, clauses like that are often found to be certain enough. Astor Management AG confirmed this. Courts interpret them by asking what a reasonable party would do. So uncertainty isn't just about missing numbers. It's about whether the obligation is clear enough.
All right, intention, check. Certainty, check. That brings us to the final piece. Completeness. What does this add? What does it mean for an agreement to be complete?
Okay, completeness basically means the parties have got to have reached agreement on all the essential elements of their bargain. The core deal has to be settled. Nothing fundamental can be left hanging, left outstanding for future agreement.
So how is that different from certainty? They sound really similar.
They're very, very closely linked. You could even say completeness is an aspect of certainty. If an essential part is missing, the whole agreement is inherently uncertain because you don't know what the full deal actually is.
Right.
If parties explicitly say, we'll agree the price later, or delivery dates to be determined, then the agreement isn't complete yet. No contract is formed. What's essential depends on the deal. The price is usually essential, subject matter, sometimes duration. If those are missing or undecided, the agreement is likely incomplete.
And courts won't just fill in those gaps.
Generally, no. The material is clear on this. You can't take an incomplete bargain, one missing essential terms, and magically turn it into a contract by asking the court to imply those terms. You need a fundamentally complete bargain first. Then maybe that complete bargain can be supplemented by implied terms, like terms implied by law or custom. Wells v. Devani reiterated this.
This sounds exactly like the rule against agreements to agree.
It is. It fits perfectly here. It's a really core rule in English contract law. There is no such thing as an enforceable agreement to agree. Let's repeat that. There is no such thing as an enforceable agreement to agree.
No agreement to agree.
If parties just state that essential terms will be sorted out later, that initial statement itself is not a binding contract.
Is there a main case for that?
Yes. Courtney and Fairbairn, Ltd v. Talani Brothers, Hotels, Ltd, repeat, Courtney and Fairbairn, Ltd.
Courtney and Fairbairn, Ltd.
In that case, one party agreed to help the other find finance for a hotel project, on the understanding that they would then negotiate a building contract for the hotel. The finance was found, but they couldn't agree on the building contract terms. The court said the initial agreement was just an agreement to negotiate. It wasn't an enforceable contract because the essential terms of the building contract itself were never agreed, only that they would try to agree them. Unenforceable agreement to agree.
Any others like that?
Yep. Barbudev v. European Cable Management, Bulgaria, EOD. Repeat. Barbudev. An offer was made to invest in a company on terms to be agreed. Again, court said, classic agreement to agree, unenforceable.
And the reason is the same as for certainty. The court would end up making the contract.
Precisely that. If the parties themselves haven't nailed down the essential terms, the court can't step in and decide what those terms should be. That's not interpreting, it's creating. The court simply refuses to complete an agreement the parties left incomplete.
But hang on. Can parties make binding agreements about the negotiation process itself, like agreeing not to talk to anyone else for a bit?
Yes, that's a really important distinction. While a simple promise just to negotiate in good faith is generally seen as too uncertain to be enforceable, Lord Ackner in Walford v. Miles famously said negotiation involves opposing interests, making good faith hard to define. Repeat. Walford v. Miles found no implied duty to negotiate in good faith.
Okay, so agreeing to negotiate in good faith is usually out.
Right. But agreements not to negotiate with third parties for a specific period known as lockout agreements are generally enforceable. Pitt v. PHH Asset Management Ltd. is the key case. Repeat. Pitt v. PHH Asset Management Ltd.
Pitt v. PHH Asset Management. Lockout agreements.
There, a buyer got the seller to promise not to consider other offers for a fixed time. That negative promise not to do something was considered certain enough and binding.
Okay, and what about agreeing to try really hard?
Yes, agreements to use reasonable endeavors or best endeavors to achieve a certain outcome are also generally enforceable. We mentioned Astor Management AG v. Adelia Mining Pilek earlier. Repeat, Astor Management AG. Those aren't agreements to agree, they're agreements to apply a certain level of effort, which the courts feel they can assess objectively.
So, subtle but important differences. You can't enforce a promise to reach an agreement, but you can enforce a promise not to talk to others, lockout, or to try your best endeavors.
Exactly. It's about the certainty of the obligation itself. Activity 4.9 gives that classic example of incompleteness, offering £200 K for a house subject to contract. Even if the seller replies accepted, the subject to contract phrase means it's deliberately incomplete. The essential step, exchanging formal contracts, is missing. If you find damp, you can pull out. No binding contract yet.
Right. Subject to contract signals incompleteness. Are there any exceptions? Times when courts can fill in missing essential bits?
Yes, a couple of limited situations. One big one is where legislation steps in. The best example is Section 8.2 of the Sale of Goods Act 1979. Repeat, S.8.2 of the Sale of Goods Act 1979.
Sale of Goods Act, Section 8.2. What does it do?
It says that if a contract for selling goods doesn't determine the price, the buyer must pay a reasonable price. So the statute itself provides the missing essential term, price, allowing the contract to be enforced. It effectively completes the agreement in that specific scenario. Repeat, Esplanade 22 SGA 1979 can complete a sale of goods contract by implying a reasonable price.
Okay, so statutes can help. Any other way?
Yes. The other main one links back to what we said about certainty reliance and part performance, where parties have clearly acted as though they have a binding agreement. Even if an essential term wasn't explicitly spelled out, courts have sometimes been willing to imply the necessary term to complete the deal and avoid unfairness.
Like which cases?
Foley v. Classic Coaches Ltd. is a good example. Repeat, Foley v. Classic Coaches Ltd. And British Bank for Foreign Trade Ltd. v. Novinex Ltd. Repeat, British Bank for Foreign Trade Ltd. v. Novinex Ltd.
Okay, Foley and Novinex.
In Foley, there was a deal to buy land linked to an agreement to buy petrol from the seller at a price to be agreed from time to time. They acted on this for years. The court implied a term that the price should be reasonable and that disputes could go to arbitration. They completed the agreement based on the long-term performance. In Novinex, an agency agreement didn't specify how long it lasted. Based on performance, the court implied it was terminable on reasonable notice.
Why do courts do this here when they normally say no completing the bargain?
Good question. The material suggests two main reasons, really. First, protecting reasonable reliance. It just seems unfair to let one party back out after the other has acted on the deal, maybe spent money, changed their position.
Right, fairness.
Second, the parties conduct their reliance. Their performance gives the court evidence. Evidence of what they must have implicitly intended the essential framework to be. The court isn't just inventing terms, it's inferring the terms necessary to make sense of the bargain the parties clearly thought they had and acted upon. Repeat. Rationales include protecting reliance and inferring original intent from conduct.
That makes sense. Activity 4.11 asks about these instances where courts imply missing essentials and why. It points straight to Foley, Novinex, and the Sale of Goods Act. It shows that while the no agreement to agree rule is strong, courts aren't totally rigid if there's a legal basis like a statute, or strong evidence from conduct showing the parties treated the deal as binding enough to act on.
Exactly. So, wrapping up completeness. The agreement must contain all essential terms, either expressly or via a clear mechanism. Courts won't make the contract for you. An agreement to agree is a non-starter. But remember the exceptions. Legislation, like SGAS on 8.2, or significant reliance part performance, Foley, can sometimes allow courts to imply necessary terms and complete the deal. Repeat. Completeness requires all essential terms, no agreement to agree. legislation or reliance can sometimes allow courts to complete.
Wow. Okay, that was a really, really thorough exploration. We've properly navigated intention to create legal relations, certainty of terms, and the need for a complete agreement.
We have indeed. And remember, these three, intention, certainty, and completeness, they aren't just minor details. They are absolutely fundamental requirements for a contract to exist, sitting right alongside offer, acceptance, and consideration. Let's repeat those three again. Intention, certainty, and completeness.
Intention, certainty, completeness. Got it.
They really tell us a lot about the whole idea of contract law being based on consent. It's not enough just to swap promises. The parties have to objectively intend that swap to be legally binding, and the scope of that deal needs to be clear enough and settled enough for a court to actually enforce it.
Yeah, it's fascinating watching how the courts balance respecting party freedom, the freedom to decide not to be bound with finding practical solutions when people have clearly acted like they do have a deal, even if it's a bit messy on paper or wasn't made in a formal setting.
It really highlights that judicial tightrope walk, doesn't it? Interpreting what the parties wanted, but drawing a line before they start writing the contract themselves. Unless, of course, specific legal rules or the parties' own actions give them a solid basis to imply or complete terms.
So the big takeaway for everyone listening, especially those studying, maybe it's that context, clarity, and showing a real commitment to be bound are absolutely vital, whether it's a family arrangement or a multi-million-pound commercial deal. Look beyond the basics.
Absolutely. And for your exams, whenever you see an agreement described in a problem question, consciously ask yourself those questions. Was there objective intention here? Are the terms certain enough? Is anything essential missing? And then use the cases. Use Balfour, use Merritt, use Scammell, Hillis, Courtney, Foley, Radmacher, Blue, McGinns. Let's repeat those key names one last time. Balfour, Merritt, Scammell, Hillis, Courtney, Foley, Radmacher, Blue, McGinns. They are your analytical tools. Understand the reasoning in those cases.
Okay, brilliant. And a final provocative thought for you to mull over. With so many discussions, negotiations, even agreements happening informally online, now texts, WhatsApp, social media, how might courts continue to apply these traditional principles of intention, certainty, and completeness in that digital landscape? Does the objective test need tweaking?
Ooh, that's a very relevant question for where law is heading. A lot to think about there.
Indeed. Well, this deep dive was made possible by that valuable educational material from the University of London. We're very grateful for that.
And it was brought to you by Sinorbit Academy, Sri Lanka.
So, to everyone out there studying hard for exams, from both of us, sincerely, the very best of luck. You're doing great. Keep digging in.
Keep diving deep.
We'll be back soon with another deep dive.